Conditions and warranties. At the time of selling the goods, a seller usually makes certain statements or representations with a view to induce the intending buyer to purchase the goods. Such representations are generally about the nature and quality of goods, and about their fitness for buyer's purpose. When these statements or representations do not form a part of the contract of sale, they are not relevant and have no legal effects on the contract. But when these form part of the contract of sale and the buyer relies upon them, they are relevant and have legal effects on the contract. Introduction. Condition. A condition is a stipulation essential to the main purpose of the contract, the breach of which gives rise to a right to treat the contract as repudiated. Warranty. A warranty is a stipulation collateral to the main purpose of the contract, the breach of which gives rise to a claim for damages but not to a right to reject the goods and treat the contract as repudiated. Stipulations as to time. Unless a different intention appears from the terms of the contract, stipulations as to time of payment are not deemed to be of the essence of a contract of sale. Whether any other stipulation as to time is of the essence of the contract or not depends on the terms of the contract. Caveat emptor. In case of sale of goods, the doctrine, caveat emptor, means, let the buyer beware. When sellers display their goods in the open market, it is for the buyers to make a proper selection or choice of the goods. If the goods turn out to be defective, he cannot hold the seller liable. Difference between conditions and warranties. Meaning. A condition is essential to the main purpose of the contract. Warranty is only collateral to the main purpose of the contract. Right in case of breach. The aggrieved party can repudiate the contract or claim damages or both in the case of breach of condition. The aggrieved party can claim only damages in case of breach of warranty. Conversion of stipulations. A breach of condition may be treated as a breach of warranty. A breach of warranty cannot be treated as a breach of condition. When condition to be treated as warranty. Contract of sale is subject to any condition. Where a contract of sale is subject to any condition to be fulfilled by the seller, the buyer may waive the condition or elect to treat the breach of the condition as a breach of warranty and not as a ground for treating the contract as repudiated. Contract of sale is not severable. Where a contract of sale is not severable and the buyer has accepted the goods or part thereof, the breach of any condition to be fulfilled by the seller can only be treated as a breach of warranty and not as a ground for rejecting the goods and treating the contract as repudiated, unless there is a term of the contract, express or implied, to that effect. Analysis. Section 13. Species cases where a breach of condition be treated as a breach of warranty, as a result of which the buyer loses his right to rescind the contract and can claim for damages only. Express and implied conditions and warranties. Introduction. Conditions and warranties may be either express or implied. They are express when the terms of the contract expressly state them. They are implied when not being expressly provided for. Express conditions. Express conditions are those which are agreed upon between the parties at the time of contract and are expressly provided in the contract. Implied conditions. The implied conditions, on the other hand, are those which are presumed by law to be present in the contract. It should be noted that an implied condition may be negated or waived by an express agreement. Implied warranties. It is a warranty which the law implies into the contract of sale. In other words, it is the stipulation which has not been included in the contract of sale in express words, but the law presumes that the parties have incorporated it into their contract. Implied warranties are read into every contract of sale unless they are expressly excluded by the express agreement of the parties. Implied conditions. Condition as to title. In every contract of sale, unless there is an agreement to the contrary, the first implied condition on the part of the seller is that in case of a sale, he has a right to sell the goods, and in the case of an agreement to sell, he will have right to sell the goods at the time when the property is to pass. Sale by description. Where there is a contract of sale of goods by description, there is an implied condition that the goods shall correspond with the description. This rule is based on the principle that, if you contract to sell peas, you cannot compel the buyer to take beans. The buyer is not bound to accept and pay for the goods which are not in accordance with the description of goods. Sale by sample. In a contract of sale by sample, there is an implied condition that the bulk shall correspond with the sample in quality. The buyer shall have a reasonable opportunity of comparing the bulk with the sample. Implied conditions. Sale by sample as well as by description. Where the goods are sold by sample as well as by description, the implied condition is that the bulk of the goods supplied shall correspond both with the sample and the description. In case the goods correspond with the sample but do not tally with description, or vice versa, or both, the buyer can repudiate the contract. Condition as to quality or fitness. Ordinarily, there is no implied condition as to the quality or fitness of the goods sold for any particular purpose. However, the condition as to the reasonable fitness of goods for a particular purpose may be implied if the buyer had made known to the seller the purpose of his purchase and relied upon the seller. Condition as to merchantability. Where goods are bought by description from a seller who deals in goods of that description, whether he is the manufacturer or producer or not, there is an implied condition that the goods shall be of merchantable quality. Condition as to wholesomeness. In the case of eatables and provisions, in addition to the implied condition as to merchantability, there is another implied condition that the goods shall be wholesome. Implied warranties. Warranty as to undisturbed possession. An implied warranty that the buyer shall have and enjoy quiet possession of the goods. That is to say, if the buyer, having got possession of the goods, is later on disturbed in his possession, he is entitled to sue the seller for the breach of the warranty. Warranty as to non-existence of encumbrances. An implied warranty that the goods shall be free from any charge or encumbrance in favor of any third party not declared or known to the buyer before or at the time the contract is entered into. Warranty as to quality or fitness by usage of trade. An implied warranty as to quality or fitness for a particular purpose may be annexed or attached by the usage of trade. Regarding implied condition or warranty as to the quality or fitness for any particular purpose of goods supplied, the rule is, let the buyer beware. Disclosure of dangerous nature of goods. Where the goods are dangerous in nature and the buyer is ignorant of the danger, the seller must warn the buyer of the probable danger. If there is a breach of warranty, the seller may be liable in damages. Exceptions to caveat emptor. Fitness as to quality or use. Where the buyer makes known to the seller the particular purpose for which the goods are required, so as to show that he relies on the seller's skill or judgment and the goods are of a description which is in the course of seller's business to supply, it is the duty of the seller to supply such goods as are reasonably for that purpose. Goods purchased under patent or brand name. In case where the goods are purchased under its patent name or brand name, there is no implied condition that the goods shall be fit for any particular purpose. Goods sold by description. Where the goods are sold by description, there is an implied condition that the goods shall correspond with the description. If it is not so, then seller is responsible. Goods of merchantable quality. Where the goods are bought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall be of merchantable quality. The rule of caveat emptor is not applicable. Exceptions to caveat emptor. Sale by sample. Where the goods are bought by sample, this rule of caveat emptor does not apply if the bulk does not correspond with the sample. Goods by sample as well as description. Where the goods are bought by sample as well as description, the rule of caveat emptor is not applicable in case the goods do not correspond with both the sample and description or either of the condition. Trade usage. An implied warranty or condition as to quality or fitness for a particular purpose may be annexed by the usage of trade, and if the seller deviates from that, this rule of caveat emptor is not applicable. Seller actively conceals a defect or is guilty of fraud. Where the seller sells the goods by making some misrepresentation or fraud and the buyer relies on it, or when the seller actively conceals some defect in the goods so that the same could not be discovered by the buyer on a reasonable examination, then the rule of caveat emptor will not apply.